Hello and welcome to the latest edition of the Tax Hour. I'm delighted to be joined by Michael Sherry today, and we're going to talk about all things employment-related securities. And I think this is a hugely topical area, so I'm really, really delighted that Michael's joining us. So thank you for joining us.
Pleasure, Nick. And just to say, we discussed beforehand that we might actually stray from this subject a little bit.
We might go off on tangents,
but let's see where the hour takes us.
Yes, exactly. Okay, so employment-related securities. I think the first thing to say is pretty much every company I've come across, if it's limited by shares, has employment-related securities on the basis that founder shares, certainly in HMRC's view, are employment-related.
Indeed. Although there are circumstances where I take the view, and I'm not alone, that subscriber shares are not employment-related securities.
And actually, I heard you talk about this. It's been at least 3 years ago, probably now.
Well,
a few years ago, I'm sure I heard you talk about this very topic.
It's a view I've held since 2004 when Part 7 in its present form was introduced. And it's very simple. If you ask the question, there are two questions. The first question is, if you set up a company from scratch, have you, as a matter of fact, acquired the shares by reason of your office as director or employment with the company?
Yep.
As a matter of fact, no. You've acquired your shares because you've set the company up.
Yes.
And then if you ask the question, well, Part 7's got Section 421B, it's got deeming provisions in it. Do those apply? And there are two answers to that question. So I've got the section in front of me, and it applies where the right or opportunity to acquire the securities or interest is available by reason of an employment of that person or any other person. Well, we've already considered that factually. The answer is no.
Yep.
And then there are two deeming provisions. One is for the purposes of subsection 1, employment includes a future or prospective employment.
Yeah.
Okay, so you're going to be a director. Is it by reason of the fact you're going to be a director? Well, again, factually, no, so that doesn't take matters any further. And then sub 3 says a right or opportunity to acquire is made available by a person's employer. Where it's made available by a person's employer, then it's regarded as available by reason of the employment.
Yes. Yep.
And the way the revenue reason is they're saying, well, the company makes the shares available. The company is going to become your employer.
Yep.
Employment includes future employments. Bingo.
Yep.
So there are two answers to that. One is that the deeming provision in subsection 2 saying that employment includes a future employment.
Yes.
Applies for the purposes of subsection 1 expressly.
Yep.
So it doesn't apply for the purposes of subsection 3.
Right.
Subsection 3 in turn applies for the purposes of subsection 1.
Yeah.
And it says if the right or opportunity has been made available by your employer, then it's deemed to be by reason of the employment.
Yep.
So, but you haven't got an employment now. The fact that you will have a future one applies for the purpose of subsection 1, but not subsection 3. So it doesn't apply to this deeming.
Understood.
So if you acquire the shares before you become a director, because it's on formation, then it's not by reason of a future employment, or even if it's connected with it, that doesn't.
Right,
not
and
fatal.
Because of effectively the ordering of 1, 2, and 3.
Exactly.
So,
and then there is a further point, which is that the deeming in subsection 3, that because your employer, or let's say future employer, give the revenue the benefit of the doubt, has made the shares available. Well, when you form a company, the company doesn't exist.
This is exactly what I always come back to.
Exactly.
Like, if it doesn't exist, how can it make
it? And you acquire the shares. If you're a subscriber member and you acquire the shares on subscription, you acquire the shares not by reason of a right or opportunity made available by the company,
Yeah.
but rather by reason of a right or opportunity made available by company law.
Yes.
It's
Yeah.
by operation of law that you get
Yeah.
your subscriber shares. Of course, anything you do after that,
Yes.
that argument falls away.
Yeah, exactly.
There is another argument, which is that when the legislation in subsection 1 of 421B says by reason of a right or opportunity made available by your employer,
Yep.
there is an argument which has been there since 2004, which is that implies that your employer is doing you a favor.
Yeah.
So the words a right or opportunity made available by your employer.
Yeah.
So simply issuing shares is not, this argument runs, aptly described as a right or opportunity made available by the company.
I take that point.
Indeed, what normally happens is you apply and the company then allots.
Yes.
So it doesn't give you a right or opportunity to subscribe. It responds to you giving it a right or opportunity to take your money.
Yeah. It's kind of like what they do in the law is in shops, isn't it? Where it's like an invitation to treat kind of scenario, isn't it? Yeah.
So and if you're paying, it's your company, it's £100 company, you pay £100. Where's the benefit? Where's the right or opportunity made available?
Yeah.
That language implies that the company's doing you a favor.
Yeah. How does that logic then, when we talk about if you were to issue shares at a later date and the individual pays market value, could we not have the same type of argument to say?
Absolutely.
Right.
Absolutely. So this brings us to Vermilion.
Yes.
Because this argument was in the taxpayer's draft case.
Yep.
But was edited out and not argued.
Oh, okay. I didn't realise that. Right.
And the other argument I put forward as to the relationship of subsections 1, 2, and 3 was also in the taxpayer's case and was also edited out.
Oh.
Now
I'm disappointed that it was edited out.
So those two arguments were thought about and then they weren't pursued.
Do we know why they weren't pursued?
It was when you're acting as an advocate in litigation, you take many strategic and tactical decisions about how to argue the case.
Right.
And I don't know the specific reasons why those arguments came out. It
wasn't part of their strategy.
But whoever took the decision decided they were better to go with what they had. And what they had effectively in the decisions below was here was individual who'd been part of the original funding round for the company. Company needed more cash.
Yep.
Still a good idea, but it hadn't got enough funding for whatever reason. The backers said, yes, we'll put in more money, provided one of our number becomes chairman.
Yep.
And so the individual who had been involved in the fundraising side of it and providing the funds got parachuted in. Now, he'd had options from the beginning.
Yep.
Part of the deal was, well, you're going to go in as the man in charge. You'll be paid. So, and your options were really a fee for arranging the funding in the first place.
Yep.
So we want your options cut down because you're going to be paid.
Yeah. Yep.
All of which makes sense. And then the lawyers decided to implement that by cancelling the old options and issuing new ones on exactly the same terms.
Yep.
but fewer.
Yes.
And the only advantage, as it were, to the individual of that process, and I'm using advantage in inverted commas, is that because they've been reissued and they were on exactly the same terms, the end date for exercise was further into the future than the original end date.
Yeah.
But that was kind of done without thought. It was just, well, we'll reissue on the same terms.
Yep.
And that was just because it was easier as a matter of drafting to take that precedent, redo it, and then a short document saying those old ones are cancelled, rather than to, from scratch, amend the documents which had already been drafted. So it's an interesting question. If AI had been asked to do this task, whether it would have taken the easy route, which the lawyers involved did, or whether it would have been more literal in accepting instructions to simply reduce the number of options.
Yeah.
So the position now was he'd become an employee.
Yep.
At the same time, he'd been re-granted a smaller number of options.
Yep.
And then subsequently exercised those options. Now, it was accepted as a matter of fact that he wasn't given his options by reason of his employment.
Okay.
But the revenue argument all along was, well, he was an employee or became one, so he had a future employment. 421B says if you get it by reason of a future employed, subsection 3 says if it's
deemed.
If you are an employee, it's deemed.
Yeah.
And effectively, the Court of Session on appeal from the upper tribunal said, well, he clearly didn't get it by reason of his employment. These deeming provisions, they're all around circumstances where it's unclear. They're designed to resolve difficulties.
Yes. Yeah.
And there's no difficulty here. So that doesn't arise. I'm eliding the reasoning. And the House of Lords said, no, this is a rule which is designed by Parliament to prevent argument.
Yes.
So it's not there to resolve the doubtful case. It's to prevent the doubtful case even arising. If you happen to be an employee, it's taxable as income, and that's it. Now, there doesn't appear to have been a great deal of debate in the Supreme Court about whether that really was the policy or whether the policy was still a bright line, what they called a bright line. They said this is designed to draw a bright line so that this side of it, there's no dispute.
Yep.
But there wasn't really any debate as to whether or not that bright line that Parliament intended to draw was intended to prevent disputes arising or whether it was intended to resolve disputes which would otherwise arise.
And okay.
And so if the facts are clear, it wouldn't be needed. And to my mind, that's unfortunate. But in a funny sort of way, a decision of the Supreme Court is the answer.
That's kind of the problem, isn't it? It's kind of gone all the way to the Supreme Court, so we are now bound, and that's that. And there's been a lot of, the Supreme Court decision was 2023, so we've had
back end of 23,
yeah. So we've had over 12 months now, and Vermilion has come up quite a lot in the work that I've done on transactions. Vermilion has been used to argue, or not even argue, because it is, as you say, now it's a Supreme Court case. There's very little argument to be had, isn't there now? So what does that Vermilion case then do to your arguments going back to all the way to 2004 to say?
So, interestingly, because they didn't get into the taxpayer's case, they weren't argued. So the Supreme Court decision does not determine them.
Right.
The court has not considered what is meant by the composite phrase, a right or opportunity made available.
Yeah.
And nor has it considered the interrelationship of subsections 2 and 3 to each other, given that each of them says for the purposes of subsection 1.
Do you think that's ever going to get argued, given that we've got Vermilion? Do you think we're going to have a case where we say, okay, well, regardless of Vermilion, we're going to still...
And the answer is eventually yes. Okay. And the reason I say that is because Vermilion itself should never have happened. It was only because of the odd fact that of the way the new options were drafted as new options instead of an amendment to the old one.
Right.
There was another argument which wasn't really put to the court, which would have been, well, in substance, the new option is actually the old option cut down.
Yeah.
And there is a capital allowances case, a decision by McGarry in relation to capital allowances where, and I'm trying to rack my brain to remember the name of it, but the revenue were arguing where there'd been a sale and leaseback, that there'd been a disposal of the whole interest in the property and an acquisition of a new interest, and that amounted to a disposal event for the purpose of capital allowances in those circumstances of that particular case. And McGarry said, this idea of disposing of the freehold and then acquiring the leasehold in a sale and leaseback, it is an accident of our conveyancing law.
Right. Yep.
And the reality is that the commercial substance here is that the taxpayer has disposed of the freehold reversion.
Yeah, because it's all one transaction.
Exactly.
I know technically there might be, under the law, it's a sale and then a leaseback.
So it's if you're in the law of property, it's the disposal of one estate in the land and an acquisition of a new and different estate in the land. As a matter of land law, but commercially, that you still got an interest in the land. You had one before, you have one afterwards. You still got an interest, and that was the issue. And McGarry said, "Well, that's how we look at it from a tax point of view." So, if the exact facts of Vermilion have been argued on the basis, well, in substance, this is exactly the same option, and the fact that it's a bit longer is irrelevant commercially, because it makes no difference, because it was now that would be a factual argument for the first tier tribunal to decide whether or not that extension of the timing was just an error, not something that was intended, or was something that was important or real. So that's a way. But Vermilion arose because everybody was aware of how the revenue interpreted 421B.
Yep.
So it should never have been drafted the way it was.
Right. So are you saying...
So my view is that there will be other cases where people have made mistakes.
Yes.
And the only way to avoid what I would call a windfall tax charge for the Exchequer is to raise the arguments that I've talked about.
Yeah. So if we go to look at the Vermilion case itself, if we have another identical scenario, except that we've had Vermilion, they, instead of cancelling those options and issuing new, if they just replace or amend the
original.
Are you saying that they would fall outside of ERS and Vermilion doesn't apply?
If the original options fell outside ERS and you simply cut them down, so the taxpayer gives up 10% of them or 50% of them, whatever the answer is, surrenders some of them, then he's still outside ERS, because it's the options he's got left are the same ones he had from the beginning.
If we look at the original options, we're saying that the new options that were granted by reason, or sorry, we aren't, but the courts were granted by reason of a future employment. Well, he did have a future employment even when we granted the original options. It's just we didn't know about that because circumstances changed. So could there not also be an argument that whenever those original options were granted, at some point down the line, whether it's 5 or 10 years, an employment did happen, so it should therefore still fall within the same deeming rules?
I want to be in the courtroom on the taxpayer side if the revenue try to argue that, because I will be so confident of winning. No.
Yeah.
That's a hostage to fortune, isn't it?
But I think I guess what I'm trying to say is, where's the line? Because in this case, he pretty much immediately became, when they granted the new option.
The new options and the taking up of the new employment, and it was contractually connected.
Right. So
there couldn't be any argument, because the whole deal with the new options was he was going to become the chairman.
Yeah.
And he was going
so it's quite clear cut there, really, isn't it?
The operation of reducing his old options and taking away his old ones and giving him the new ones was tied up with that.
So what about if we were to issue some shares as let's say a fundraising round, and so an investor invests say 100 grand for some shares, and 6 months later the company's not growing as well as we wanted, so the investor says, I'll come in and I'll work 1 day a week and give you some guidance. Mm-hmm. So at the time you issued the shares, he was just an investor, not employment related.
Sure.
It's only 6 months down the line and suddenly he's become an employee. Does that make them employment related, or the fact that at the time we issued the shares 6 months before, we had no intention of making him an employee?
So my view is that it doesn't.
Right.
Because subsection 3 applies temporarily to somebody who is an employee.
Right.
And so the deeming provision doesn't apply before you become an employee, unless the right or opportunity is made available to you as a future employee.
Yes. So in my example, we had no intentions of making an employee, so can't be employment related, even though it's only a small gap.
That's my view.
Yeah.
The courts are very fond these days of saying Parliament couldn't possibly have meant to let you get away without paying tax in particular circumstances. That same argument runs, at least to some extent, in favour of taxpayers if it's presented properly. It's interesting if you think about the change in interpretation of statutes. We've got this general movement. It's been articulated in the tax avoidance cases that we're familiar with, which is construe the statute, interpret the statute purposively, and apply it to the facts, taking a realistic view of the facts. And those two elements reflect, as Lord Steyn said in McGuckian, developments in the general law, and fiscal law is not immune to that. There is, however, a forgotten reason why fiscal law took perhaps a different approach. And at some point, I expect this to perhaps come back into fashion a little bit.
Right.
Hasn't done yet, and there's no signs of it, but let me explain.
Okay.
So, amongst the principles that Lord Wilberforce enunciated in Ramsay, which he said these are clear and established principles, one of them was the subject is only to be taxed by clear words.
Right. Yeah.
He then went on to say, and the whole of this line of cases running afterwards, so far as it's concerned with interpreting statutes, it is hangs on what Wilberforce then said and follows on from it.
Yeah.
He then went on to say, of course, clear words doesn't mean you're confined to a very narrow, literalistic interpretation of the word.
Yeah. Yeah.
You've got to interpret it in context.
Yeah, absolutely. Okay.
But the principle is still there. No taxation without clear words.
Yeah.
And you can, if you forget that principle and simply say, oh, well, we're searching for Parliament's intention. Parliament can't possibly have intended that you get away without paying tax in these circumstances.
Yeah.
Even if the words are clear and there's no way you can interpret them either literally or contextually as meaning something else,
Yeah.
that you can't do. So there are limitations.
Yeah.
And the reason, if you go back to the reason for the original principle, no taxation without clear words, it's because the government is taking your money away. It's taking your property away.
Yeah.
If you think about this in more modern terms, the European Convention on Human Rights has the right to private property in it.
Yep.
Yes, of course, there is a carve-out for taxation, but not for confiscation. So it will always, the European Court of Human Rights will always defer to the local courts as to what does the tax provisions mean.
Yep.
But they do have to mean
Yes. Yeah,
that you are obliged to pay the tax.
Yeah.
And so that's one way of looking at it, that there are limits to what purpose of interpretation, what is sometimes called teleological approach, looking for the purpose behind the thing. Because with the taxing statute, the purpose is always to raise taxes.
Yes.
So if you approach the thing at a sufficiently abstract and high level, you will always say, well, the idea is to raise money, so you've got to pay. And this principle of no taxation without clear words is a limit to purposive interpretation. Just engaging in that process of, well, how do you ascertain what the parliamentary intention is? And more than once, the courts and the judges have said at the highest level, you ascertain that purpose from the words Parliament has used. So there are limitations. And another reason for those limitations is that compliance with tax code is potentially, one, it's confiscatory of your property, but non-compliance is a criminal offence.
Yep.
So the tax charge has to be clear. People have to be able to know.
Yes. Yeah.
And
isn't that one of Adam Smith's pillars as well? So
wow.
Goes back hundreds of years with that concept.
But it goes back to the Civil War.
Yeah.
And, Parliament passes the law. We all know what our rights and responsibilities are, and it's our duty as a system to make ourselves aware of that. So if you're looking at a circumstance where the words are not clear, I'm not sure Vermillion, these words
examined it.
I'm not saying that Vermillion was wrongly decided on these principles at all.
Yeah.
But I do think there are limits, and that there is a good reason why the courts used to approach tax law in particular in a rather restrictive way, giving the taxpayer the benefit of the doubt. It's because it's confiscatory, and it's because it's backed up by the criminal
that's really
law.
interesting.
Ultimately by men with guns.
Yeah. No, that's fascinating. You talk about kind of the principles of the legislation, kind of even going back a step from what we've talked. So that's That's interesting.
So I'm sorry, we've got rather far away from
we had a script when we started this. I haven't got very far with the first bits. No, but I'm too interested in what we're talking about. So effectively what we're saying, I think, is, all the cases that I've come across since Vermilion have very much said, look, this is that, and the Vermilion kind of stamps out every kind of if there's any kind of employment whatsoever, it's deeming provision, Vermilion applies, case closed.
Certainly, that's the revenues.
And I think that's been the revenues approach even way before Vermilion. It's been in there.
So let me postulate a case which I've come across, which is really fascinating. So an entrepreneur controls a company. It floats. It has private equity. Well, it has private equity backing.
Yeah.
And there's an end date.
Yep.
By which the private equity want to get out. So a deal is done, which effectively the object of the exercise was to allow the entrepreneur founder to acquire the private equity shares at a price which would give them, they'd be very happy to exit at before their target exit date. The idea being that if there's a problem with a float or a refinance or whatever, he can step in, acquire those shares, and then there can be an orderly further fundraising and so on. But if they're just on a cliff edge because of the date the private equity firm has set for their exit, commercially it's bad for the company. Now, there are a number of ways in which that could have been done. And one way would have been for the private equity firm to grant him an option to acquire in this way. But for reasons best known to the advisors who were acting at the time, the way it was actually done was to give the company a right to buy the shares in.
The PE shares.
Yeah.
Yeah.
In circumstances where the entrepreneur founder had preemption rights.
Yes, okay.
So I think the preemption rights have been in there since day one.
Yeah.
And it was thought, well, he's already got those preemption rights. So if the PE house grant the company an option to buy the shares in, his preemption rights will be triggered. And so, that just the way people draft these things.
This is actually interesting. I mean, I've actually come across this quite a bit in terms of where even if it's just shares granted to one employee, and then articles vary whether or not that, if the employee leaves, so bad leaver clause kicks in. I've seen articles which say that the majority shareholder buy the shares off him.
Yeah.
The company buys them back, or like your example, CPOS, but with the preemption.
So this particular case, there was a shareholders agreement that the drafting was not entirely clear, but the starting point pre-Supreme Court decision of Vermilion was we don't need to worry about this because this is all to do with capital funding. It's got nothing at all to do with employment. Then Vermilion decision comes out, everybody panics. And of course, as soon as the decision comes out, a letter comes out from the Revenue. There's been ongoing correspondence for ages saying, by the way, why does your man think that he shouldn't have returned this as income tax, and why has the company operated PAYE? See Supreme Court decision of Vermilion. The answer, of course, to that was, well, at the time, we were looking at the Court of Session decision of Vermilion, so go away. But it raises an interesting point because in the circumstances of that particular case, the revenue arguments were all to do with, well, the company didn't buy the shares in, and the individual did, and da-da-da-da-da. But the real reason the individual in that case was able to buy the shares was because of the preemption right.
Yep.
The preemption right was in the articles.
Mm-hmm.
The company's original articles, when formed, when it was set up as a £100 company, didn't include that preemption right.
Right.
The preemption right was put in when they did their first EIS fundraise.
Yep.
So, arguably, was that a right or opportunity made available by the company? So, this issue that we've been talking about,
Yeah.
what do those words mean?
Yeah.
That case might litigate.
Yeah.
And it's not solved by Vermilion in that circumstance because it's not something the company's done.
No.
Other than by adopting articles which include a preemption right. But is that a right or opportunity made available by the company?
Would it make a difference if those preemption rights were in from day one, do you think?
Well, yes, because it's not made available by the company, but by operation of law. The company doesn't exist until you've registered the articles in Companies House.
Yeah. So is a company doing something because it's forced to, because its articles say that so? Are we saying that potentially that's not a right or opportunity made available by the company because it has no choice in doing it? Or
well, this is where you ask the question, a teleological question, a purposive question. When Section 421 includes the words employer, clearly that includes the company as a corporate entity. But in company law, at one level, the company is the collection of its members.
Right.
Acting together, given a corporate, a fictional legal personality.
Yeah.
But the only real people involved are the members.
Yeah.
So they are the company. Well, no, they're not, because we've got this artificial legal person.
Yeah.
So who is it that caused those articles to be put in place? It was the members.
Yep.
So at one level, you might say, well, that's the company. But at another level, you say, no. It's not the company, it's the members.
Yeah.
So that's fascinating.
We don't have an answer to that then, do we?
We don't have an answer to that. So that case may litigate. I think the answer to that is it's the members who pass the special resolution which adopts the articles. And that then, the company doesn't have a choice. It's not making anything available. It's doing what the articles
say it has
to do.
Yeah. You're right. It is fascinating. It'd be interesting if that does litigate. And
I may be long gone before it gets anywhere near a courtroom.
Well, let's hope we get some answers, because all of this does, especially I think in due diligence cases on transactions, all of this becomes, I think, very technical and to some extent academic. Even some of the smallest issues become major issues on a transaction, just because, of cases like Vermilion, and whether there's, whether they're readily convertible becomes another question, and all the rest of it. So, and it takes a lot of time and resources to.
It does. So practical solutions are flavour of the day. And we were talking about one of my cases before we started.
Yeah.
In that particular case, the company had a share scheme. An individual had options under the scheme, a share option scheme.
Yep.
There was a general offer for the company. He exercised his option. The company secretary reached for the paperwork that they'd used the last time this had happened, executed it all, and he got his shares. It was only when the purchaser came along and said, doing their due diligence, said, you've given him the wrong class of shares. Because the last time a share option had been exercised, there'd only been one class of shares.
Yeah.
But this guy, his option was over a particular class of shares, which, for the sake of argument, let's say he should have got shares which were worth 20 or 30 grand, which he was going to cash in on the sale.
Yep.
he'd actually got ordinary shares which were worth, let's say, 120 grand, 100 grand more.
Yep.
Nobody was going to give that to him. He was leaving anyway. He wasn't going to argue the toss about this. He was very grateful to get 20 grand. But he certainly didn't want a tax charge on the extra 100 grand, an income tax charge.
Yep.
It would have been possible, maybe, maybe not, to go to the court and get the transactions rectified. Maybe they could get a rectification at the share register. Maybe not. I mean, there are issues. Rectification's a wonderful remedy.
Yeah.
You ask the court to put a document right that's gone wrong. But there is a school of thought which says in areas of statute law where it says if you do this, the result is that once you've done it, that's it. The court has no jurisdiction to interfere with the statutory outcome. So maybe we could have rectified, maybe we couldn't.
Yeah.
What the company decided to do, or was seeking advice on, the preferred course of action was to simply reclassify his shares from A shares to the C shares they should have been.
Yep.
And then proceed with the disposal to the purchaser. Yeah. And that would mean he would only get his 20 or 30,000. He wouldn't get the extra 100,000 because he'd be disposing of that class. Yeah. But that left open the question, well, what was the appropriate tax charge when he exercised and the company gave him the wrong shares? Now, you have to work backwards, mixing company law with tax law here. So given that the company was going to reclassify his shares back to what they should have been, that doesn't mean to say he didn't get the ordinary shares.
First place, yeah.
However, if you ask the question as a matter of general employment taxation, what was the value of what he got? Well, he was always going to suffer this fate. Yeah. The company was always going to say, nah, you can't keep an extra 100 grand. And the action of passing a special resolution to reclassify those shares, although prejudicial to that shareholder, it wasn't unfairly prejudicial.
No.
So he could never have gone to the court to complain about that happening to him. And on that basis, if any purchaser of those shares he'd been given knew the circumstances, they would know that those shares were going to be reclassified in that way.
Yep.
So they would never pay the full market price for ordinary shares for that individual.
The C shares, which were only ever worth
This is the argument anyway. And therefore what he got was only worth 30K.
Mm-hmm.
And that was the market value of what he got.
Yeah,
and that resolved the whole question of what he was taxable on.
Right. It's interesting though because you've literally just in the space.
But they've taken a risk in those circumstances. An indemnity was given by the vendor.
I was going to say you have to have some
to
sort
the
of
purchaser that if there was a PAYE liability in respect to this, if the revenue raised it, then they would cough up.
But I do think it's interesting from in that 2 minute point that you just made. You've covered company law, tax law, valuation principles. You know, there's a lot. I mean, I would say I can do the tax valuation. I can do at a high level, but I would never, I would always be using an expert on the valuation point, and I certainly wouldn't be advising on company law. So you've got three different, in a lot of cases, three different people advising the one point.
And most valuers would want input from a lawyer.
Yeah.
On the tax and company law implications of what had happened. And then they say, oh, well, that's easy. They're only worth 30K.
Yeah.
So I'm not going to give you a valuation advice as an expert valuer because I'm not going to do the sums.
Yeah.
Which, for a corporate valuation or whatever.
Yeah.
But I will give you the principles. And so a case like Gray's Timber, where I appear for the taxpayer, raises fascinating
Should we talk about Gray's Timber and as we're coming across it? I know we keep saying we'll come back to the other things. We could talk for the whole hour on what employment related means, couldn't we? But
we could, but we've kind of touched on that to some extent. But we could talk more about that. But if you want to talk about Gray's Timber, so just to remember, the family who owned the company decided that it had been a family company for donkey's years. They wanted to get the group ready for sale. So the member of the family who was running the group decided that he needed to step back from the day-to-day management of the main trading company and sort out looking for buyers, sort out structuring the group, sorting out the minority shareholders and making sure everybody was on the same page, so on and so forth. So they sought an individual to come in and manage the business and to be paid a proper rate. Mm-hmm. And ironically, that they insisted that the individual who came in buy some shares.
Yep.
And they said, the company's worth, let's say, 10 million. You're going to have 10% of the shares. You've got to pay $1 million. Mm-hmm. Now, that's over and above market value.
Yep.
Because he's got a small minority interest.
Yep. Minority
discounts. Maybe the shares he was getting were only worth 200,000.
Yeah.
But as part of the deal, he was going to get, as and when there was a sale, not 10% of the proceeds, but 20%. Mm-hmm. So it could have been argued in Gray's Timber that when he got his 20% on an ultimate sale, he'd actually paid for that right.
Yes.
Yeah. But that would have involved lots of valuation evidence.
Yes.
Definitely. At first instance. And we could fight the case at first instance in those days before the special commissioners relatively cheaply on an agreed statement of facts.
Yeah.
But if we were going to introduce contested valuation evidence and expand the areas of argument, we were going to get into trouble. Yeah. Because we were instead what was a one-day hearing would have become a week's hearing or longer.
Yeah.
So the vendors who were faced with the PAYE charge on that excess value that the manager had got when the group was sold, the difference between his 10% of the shares and the 20% of the proceeds he got.
Yep.
There was about 300,000 or 400,000 at stake. Right. And the family said, well, we'll pay for the litigation, but not the expensive litigation.
Right.
So that meant we were confined to arguing that the shareholders' agreement, which gave him the right to the 20%, dictated the value of his shares.
Yeah.
And therefore, when he sold his shares to the purchaser and got the 20% that everybody had agreed he should get, and which the sale contract provided for, so it was coming from the purchaser, not from anybody else, that was the value of his shares. That was his entitlement. Mm-hmm. The decision in the Supreme Court, and this was the first tax case in the Supreme Court.
Right.
It was also the first, when it changed from being the House of Lords.
Yeah.
And it was the first appeal from Scotland in the Supreme Court.
Yeah.
So
familiar with Scotland as well, wasn't it? They're all Scottish cases.
By the by.
Yeah.
The Supreme Court decided that if you're looking at the traditional cases on share valuation, the shares are the shares. And so this right to get more money was not a right attached to the shares. It arose under the shareholders' agreement.
Yeah.
And therefore didn't affect the value of the shares.
Mm.
Now, this has implications for the meaning of restricted securities.
That's literally what I was about to come on to.
I just want to mention this in passing because I want to. There was another element to the decision in Grace Timber.
Yep.
But so far as restricted securities are concerned, there's a right or restriction which reduces the market value of the shares.
Yeah.
So theoretically, Grace Timber decides that if you have a right or restriction which isn't in the articles but is in some other kind of agreement, which doesn't therefore affect the value of the shares, it's not going to be a restricted security. Fascinating.
Is that for both valuation and the concept of restricted security?
Yeah, because the concept of restricted security turns on there being an effect on the value caused by the restriction.
Yes, okay.
And Grace Timber says if it's not in the articles.
Yeah.
But the Supreme Court went further and said, but even if we concede for the minute that a shareholders' agreement could bear on the articles, and the argument ran something like this: well, the companies are a party to the shareholders' agreement, and therefore it's all part of the same deal. So even conceding that for the moment, the right to the 20% sale proceeds was particular to Mr. Gibson, who was the manager who'd been engaged, and therefore that can't affect the right of the security, the value of the securities, the market value of the securities, because it's particular to him. As soon as he'd sold, that right evaporated. That element of the decision has absolutely fascinating implications for inheritance tax.
I don't do inheritance tax, but
well, if you think about valuation on a death, and you do get involved in valuation.
Yeah,
if you've got a right which doesn't affect the value of the shares are left under the will. They are what form part of the estate, but the right exists during the individual's life, but disappears on his death.
Yeah,
then it doesn't get valued in the estate.
No.
Isn't that interesting?
It is, because
the kind of rights you can imagine are rights to receive bumper dividends, the right to have bumper voting rights, golden shares in effect.
Yeah.
So the golden share is worth everything whilst the man's alive, or the woman's alive, as the case may be. And then they fall over, and those rights evaporate.
Yeah, so obviously with inheritance
so their
tax,
share, that the share they've got left is pretty much worthless. So given we've no longer got 100% business property relief, this might be of real interest to entrepreneurs who don't want to give up the reins or can't afford to give up.
Yeah. Because, I mean, I've done loads of planning already. We haven't even got the legislation yet, and I've already had loads of conversations about this business property relief and what we can do with shares, and talking about growth and freezer shares, and all of those types of things. But you're right. It's fascinating how this principle of, if it's a particular right to that individual. I guess the other question is, I was just thinking whether that right could carry over into the estate in some form. If and I'm thinking more like family companies. If you've got a third party, then obviously the right is going to be particularly to that employee. But I
mean, it's not quite as simple and straightforward as I've said, because there are those funny provisions in the Inheritance Tax Act about alterations to the articles of closed companies.
Yeah.
Query whether or not a right expiring is an alteration to the article or not. And there are also provisions in the Inheritance Tax Act about alteration to the value of assets occurring by reason of the death. So all of that needs to be taken into account. But sorry, I should mention that before anybody goes off and thinks, "Oh, this is a brilliant idea." It is a really interesting area, and there is gold in those hills. But
I think the key thing here is when you're advising on something like this, I can't advise from a corporate tax perspective without including, I would include our private client director.
Yeah.
The kind of, this has to be advice that's fully understood by, there might be specialists out there who do it all, but you need that perspective. You can't just say, this works, go through your shares. It's all fine.
One of the things you wanted to talk about was alphabet shares.
Yes.
Perhaps
just about got time.
Perhaps now's the time we should touch on that.
Because as I said before we started, alphabet shares, I think is hugely topical because of we're doing a seminar on webinars on that, and huge amounts of sign up. So clearly a huge amount of interest from advisors. But I really do think there's a huge amount of advisors or companies out there that have issued alphabet shares with very little true understanding of the tax implications of them. A lot of the time it's I've got different classes of shares, so I can pay dividends differently. Yeah. You've also got companies out there who are issuing dividend only shares just so that they can pay salary or bonus as dividends,
which is still salary or bonus.
Yes. And I think that's one we can kind of cover off quite quickly, can't we? If it's a salary or a bonus, it doesn't matter what you try and call it, it's still a salary or a bonus. But bearing in mind we've got a 2 and a 3 hour presentation on this, and we've got about 10 minutes to talk about it, but I just thought it'd be we couldn't really record an employment related securities podcast without
very, very quickly. It's not straightforward. You have to think about the settlement provisions whenever you have, whenever you use alphabet shares. You have to think about available funding. You have to think about why you're doing it. You have to think about disposals of streams of income.
Yep.
All those other odd bits and pieces, stuff that was introduced to deal with a particular tax scheme that is still on the statute book and might knock you sideways.
Mm-hmm.
And maybe they work between husband and wife. But even there,
Arctic Systems on something like
Arctic Systems is decided in the House of Lords that so long as the shares were real shares, then they weren't just a right to income. But
and when we say real, we mean capital rights, voting rights.
Yeah, but even there, you can get it wrong quite easily because you're always subject to this realistic view of the facts.
Yes.
So you think, oh, well, look at the rights in the articles. Up to a point.
Yeah, and I also get questions like, how many shares do we have to give them?
Yeah.
The answer, you certainly can't give them sort of 0.01% and expect that to be a genuine right to vote, for instance. It has to be.
Yes, and all the surrounding circumstances have to be taken into account. So I've seen school fee type arrangements where shares have been issued to grandparents. The grandparents have then settled them on trusts for the grandchildren. Then dividends have been paid into the trust to fund school fees. That's fraught with difficulty.
There was a spotlight on that.
There was a spotlight on that, and it, notwithstanding the spotlight, I think if you do it, if it's pucker, so if the grandparents use their own money, and
I think that's the key, isn't it?
And the return on the shares is appropriate to the amount subscribed, then I think it's capable of working.
Mm-hmm.
But if that's the case, you won't sell it to many entrepreneurs because it gives them no advantage. Grandparents could just pay the school fees. Or just settle cash on a trust for the grandchildren. I think the
ones that have worked or that seem to work to me are the ones where the grandparents already have the shares, or indeed it's their company, they're the founders. Yeah. Maybe the children are involved in running the business now, but the grandparents are the founders and then they settle some of their shares.
That makes perfect sense.
Yeah.
Yeah.
So alphabet shares is a very broad area. The concept of alphabet shares is just, I mean, there's no statutory definition of what an alphabet share is. It's just a different class of shares or having more than one class of shares, and you normally call them APC, hence the term alphabet. In terms of company law, I think there's issues there. Section 629 talks about whether there even is a different class of shares. Just because you call it an A and a B share doesn't
Indeed.
make it a different class.
Drafting the articles important here.
And I've seen articles that just say, well, I've seen confirmation statements, for instance, which literally just say all like ABC shares, 1 vote per share, capital in proportion to the overall number of shares, and dividends at director discretion. So each description of each class is identical.
Yeah.
So if you then look at Section 629, you kind of, again, it's a company law matter, but you struggle to see.
Oh, you're absolutely
right. And I've also seen ones that do similar, but somewhere in the articles there's one line that says, for the avoidance of doubt, these are separate classes. And I don't think that works either. I think there needs to be a genuine difference in the rights attached to each class of shares for them to be separate classes of shares. But that's company law advice, and don't take my
No, you're right in principle.
Yeah.
And it's like all these things. You can draft the things so you're certain that it's okay.
Yeah.
Or you can draft it in a way which leaves questions like this open.
Yeah, exactly.
Which do you choose to do?
But that brings me back to lots of people advise on it. Lots of companies just do it on their own accord. And I don't think it's not that it's not possible, but I think you've got to be very, very careful with both the legal drafting and the tax advice that they are genuinely separate classes of shares, so you can declare dividends independently. All of the various anti-avoidance legislations, as you say, things like the settlements and dividend streams. And so, and hence why it's so topical, and I think why so many people are interested in this area, because so many people advise on it, whether or not it's accurate or not. So I don't think we've got much more time. We can talk about alphabet shares, but I think at least we've touched on them. The other thing I think is often very, it is almost sometimes blindly relied on, is this personal relationship exemption.
Oh, yes.
So employment-related securities, we've talked quite a bit about what employment-related means. We do have an exemption from the ERS regime if effectively the rights or opportunity are made available by an individual, and it's, I'm probably paraphrasing here, but effectively it's made by reason of a personal relationship.
Yeah.
That is paraphrasing, I know.
So when you're looking at corporate, well, normally when you're looking at, we haven't even discussed what securities means, but it means any shares or securities or anything.
Options, loan notes, everything.
That looks like a security, shadow securities. But this exemption only applies to things which are made available by an individual.
Yeah.
So the deeming rule, normally, if you're employed by a company and the company is giving you securities, it's irrelevant.
Yeah.
It's not going to apply. If you're employed by a company and the individual's giving you the securities, he or she is not the employer.
Yeah. This is one I'm always really careful on. So if we're talking about the personal relationship, I always say, let's say dad wants to give some shares to son. I always say, issue shares to dad. If you want to issue new shares, dad could just issue his existing shares. But to be safe, made available by an individual, dad has to give the shares.
Yes.
I guess some people do say that there's an argument that if dad's the only shareholder, let's say, he's the one making the right available, sort of with the company in the middle kind of thing.
And this goes back to the phrase, what is meant by the words, the right or opportunity is made available by an individual.
Yeah.
So, if it's a gift, that's clearly a right or opportunity made available by the individual.
Yeah.
But a subscription will be something else.
Yeah.
Maybe. Yes, and of course there's a prior point. You have to, if you bring yourself within this exemption, so the gift is made by an individual. It's also in the normal course, the domestic, family, or personal relationships of that person. What does that mean?
Yep.
Well, dad's giving it to his son. That's fine. But you've still got a further challenge because as a matter of general principle, Section 62 might apply if dad's giving it to you because you're running the company now and he wants to incentivize you. Then it's an emolument, its earnings as a matter of general principle.
I think a lot of circumstances that we come across where, especially with family, they're being handed down to the next generation. They're handing it down because they want the children to carry on running the business. They're not handing it down because because they're family. And so I kind of think that does sometimes make me a bit nervous. I mean,
and that's absolutely the revenue are quite reasonable.
Yeah,
usually.
Yeah, that's the point.
Difficulties arise when the numbers are very large.
Yeah,
and you've got somebody sitting behind a desk somewhere with a strange postal code in Newcastle, and you've no idea where the desk is. And they just see all the noughts and say, "Oh well, we'll have some of that."
Yeah. So I do think everyone giving advice about even gifting shares directly to family members, you still need a bit of a caveat in there to say, HMRC could still challenge this. Is the only reason you're doing this, or is the main reason you're doing this because they're your children? I know HMRC manuals include an example in there where I can't remember the exact example. It's something like you gift 10 shares to 10 individuals. One of them happens to be your child or your son, I think it is. They would probably deem that to be employment related because the fact that other employees unconnected are getting some suggests that it's not because of your personal relationship, it's because they're an employee as well.
So turning that on its head, if shares are given to 10 members of the family and one of them happens to be an employee, that suggests it's got nothing to do with the employment and you're within this exemption.
Yeah. But what about, let's say you've got 3 kids, one of them is in the family and you only give them to that one.
The one employed in the
family
business.
Member,
Yeah.
Arguably, does that not give HMRC a better argument that it's employment related and the personal relationship exemption doesn't apply?
That would depend on the particular facts. So
and I've not seen a challenge. I don't know whether you
the risk of annoying those viewing this, if the company was founded by mum and there were 3 children, 2 boys and a girl, and the woman was now running the company, and mum gives all her shares to her daughter, clearly that's got nothing to do with the employment.
But it's these things that I think it is just a grey area. You have to be careful.
Very fact specific. And you can, by looking at your paper trail, you can be careful about evidencing the real donative intent of parents and what motivates them in these circumstances.
Yeah. And I do always say, if you've got a set of board minutes that actually says it, at least there's a bit more to it.
Board minutes, a letter from mum to her daughter. Our example.
Can it be WhatsApp messages these days?
And perhaps a letter to the kids who aren't getting anything, saying the reason I'm doing this is because that's what Jill's getting. You will get the house, the farm. You will get the share portfolio. Whatever it might be. Even if that's not true. And they carelessly leave a will, leave nothing to the boys, which is...
Okay, so family members I think are generally safer because HMRC do at least also take more of a sympathetic view as well. I think that, this is succession planning. We're handing it down through the generations.
And it's pragmatic on their part because if they try to litigate that kind of case... the tribunal is not going to be sympathetic to them.
No, exactly.
So it makes sense.
How many sort of more friendship, personal relationship exemptions do you see? Do you see any that aren't successful? I mean, I don't know of that many cases that have actually been tried on this, but HMRC, certainly their manuals suggest that it's extremely strict. Most of the time, if it's family members, you probably are reasonably safe depending on the facts. But if it's just, your friend from school who you want to bring into the business or is now working in the business, or if I get a lot of cases where they said, but I'm selling the business, I'm getting 5 million. These people have been with me for 30 years. And now I want to give them some shares because I want them to benefit.
Because they've been my mates through all this.
Exactly.
The revenue would normally say that's employment related. Yeah. However, I think that there are circumstances in which you can say it's not. I've worked with this person for donkey's years. And it's a mark of my personal esteem for them. And it's
I think the problem is getting someone to advise on that, and it
can be done, and it can be done. One of the crucial aspects of that is, depending on how it's done, is there a PAYE issue for the target company? Because
that's the problem in a sale. You're into fighting due diligence questions on it, and it's a lot more difficult.
And the disclosure which the purchaser wants to be made to the revenue, even though you've got advice that it falls on the non-taxable side of the line and there's no PAYE responsibility, the purchaser's going to say, well, that's all very well, but we're going to tell the revenue about it, and they can make up their mind, and then if you want to have an argument with them, you can pay for it.
Then you're into retentions, indemnities.
So in those circumstances, it might be that you advise the client to make gifts out of the cash proceeds. Maybe.
Yes. But even then, I think there's
still an issue, but it's not necessarily in the same space, and so it becomes an issue for the individual. Because there isn't a PAYE issue for the company if it's not making the payment, and if the payment's made after the sale, and the individual might have the intention of making the payment before the sale, but doesn't implement that intention until after the sale. And at that point, whether or not the individual has paid emoluments, earnings, and whether or not the individual has a duty to account for PAYE, and whether or not the recipients have a duty to put the receipt on their tax return as untaxed earnings. Those issues can be resolved on the basis of the advice they've taken and the advice as to the appropriate disclosure for them to make.
And I think just briefly to cover some timing points, normally, when you get those questions when there's already a sale on the table, and we haven't covered readily convertible assets, but readily convertible assets basically means if it is readily convertible, PAYE and national insurance applies. And if there are, it's not just, if they're listed or something, if it's a listed company and there's already an open market, but it's also if there's intentions of trading arrangements. So it does go a lot broader than just, you might, if you've signed heads of terms, you're probably within readily convertible assets regime.
Probably.
But even before then, technically, there could be an argument to say, if you already started conversations with the buyer, and then you suddenly start distributing shares, you have a risk as well.
You do.
And so if you're thinking, I've known this person for 20 years, at some point I'm going to sell, the time is now to actually give someone shares if you're going to, I think.
Certainly, there are valuation reasons for that as well.
Yeah.
So you may have decided to sell, but you may not have crystallized that decision in that it might be just, you've always had an intention to sell at some point.
Yeah.
You've now decided you're going to investigate doing it in the next couple of years.
Yep.
If you're giving away a few shares at that point, the minority discount is still going to be huge.
Yeah, exactly.
Because there is no more certitude of a sale than there would have been 20 years ago.
Yeah.
Whereas if you've got to heads of terms or you're close to heads of terms,
yeah,
then obviously there's lots of evidence lying around that there's going to be a sale, and so the minority discount has evaporated.
Yeah, exactly. I'm gutted because I think we've run over already, and we could keep talking.
Feel free to edit.
But yeah, I mean, we've been talking and talking. I'm thinking we could carry on talking, or I could at least carry on talking for another couple of hours. But thank you so much for joining me and coming down.
It's a pleasure.
It's been really interesting, fascinating. Some of those points you brought up as well. So hopefully everyone found this a useful and as fascinating as I did. And thank you for joining me, and hopefully we'll see you on the next one.
Pleasure, Nick.
Thank you.